Hi, I'm California probate attorney Scott Grossman. In this video, I'm going to discuss when a surviving spouse has to do probate and when a surviving spouse can avoid probate. A surviving spouse can avoid probate when the surviving spouse holds property in joint tenancy with their deceased spouse. You can also avoid probate when the surviving spouse is the designated beneficiary on an account. The surviving spouse can also avoid probate when property owned by the spouses is held in trust and that trust was actually funded with the property. In all three of those situations, there's no need to do probate because all of this property will pass outside of probate to the surviving spouse. If you're new to our channel, we make videos about probate litigation, and trust litigation in California. And it would really help us out if you'd hit the like button for this video and hit subscribe so you get our future videos as well. Now, there are times where a surviving spouse must do probate. This most often happens in blended families, though it can happen in first marriages as well. Most commonly, this occurs concerning the title to the house that the spouses have been living in. The way this usually crops up is simply this. Title to the house is in the name of only one of the spouses, and usually this occurs because at the time the house was purchased, one of the spouses had great credit and one of the spouses had terrible credit. So in order to get a mortgage or to get a better rate on the mortgage, title was taken in the name of the spouse who has good credit, and the spouse who has the terrible credit not only doesn't appear on title to the house, but almost always has signed a quitclaim deed saying that title to the house is entirely in the name of the spouse with the great credit. Now, you already learned that title is going to determine when probate will have to occur. So if the spouse with the great credit who had title to the house has passed away, if that house was not put into a trust, and if that spouse does not have a will, then there's no choice but to do probate in order to transfer title to the house. In blended families, it's not uncommon to find that both spouses have decided to keep property in their own name. In other words, they're not sharing it with their spouse, because the idea is when they die, they want to leave that property to their own biological children, and they are looking to exclude their spouse's biological children. In other words, all the property is going to pass down by the respective bloodlines. Now, that plan can work assuming that both spouses have put together some kind of estate plan, either trusts that get funded with that property or they individually have wills. Where the problem arises is when a spouse dies, they've got property in their own name, but they don't have a trust and they don't have a will. When that occurs, you're going to have to do probate if you're going to pass any of that property along, and it's important to know that because there was no plan of any kind, the surviving spouse is going to have a claim to some portion of that property. I hope this video was helpful to you. If it was, and you're ready to start your case, then please give us a call or fill out the contact form on our website. If you'd like even more information about the California probate process, then please take a look at our probate playlist right here on our YouTube channel.